you know, that is a matter for the appellate court.
Yeah.
But who should go to the appellate court? Isn't it the person who feels aggrieved or who feels that justice wasn't done properly? Wouldn't that have been the role for the EFCC who was doing the prosecution?
God bless you, my dear sister. Now, the person to appeal should have been EFCC or whoever was prosecuting. I don't think there was ever an appeal on this matter.
They said there was no need because
they filed another charge instead. Wrote a petition against this judge. You see, that's what I'm saying. I am not here, I'm not sitting here saying the judge was wrong to have done what he did. If he had room to exercise the discretion, and he exercised it the way he saw fit.
But you're saying that the NJC shouldn't have done what they did.
That's what I'm saying.
This is not a matter for them.
That is what I'm saying. If it is about discretion, there are procedures for correcting that, which is going on appeal. Why didn't the EFCC go on appeal? Why did they just choose to file another charge, rearrest him and file another charge, and write a petition? That is the problem with the justice system. It is warped. Because what it means is that if I lose a case, I can conveniently say, okay, why should I appeal when I can get the matter sorted out by writing a petition against a judge who probably was innocent? There is nothing wrong in a judge being wrong. A judge can be wrong.
But there's a process.
Oh, there's a process for correcting. Exactly. So if it is about discretion, it's not an NJC matter. But if it is strictly disciplinary, this man has done something wrong.
So in other words,
yes,
the NJC themselves too did not address this issue.
That's if what they published is correct, that the way he exercised his discretion was wrong, then I don't agree with the NJC.
Because if the laws are still there, the same thing can happen tomorrow.
Exactly.
Because that's what we had our lawyer here saying. I mean, Mr. Chris Akiri was here and was saying that that's where he stands as well, that he believes that the NJC was playing to the gallery.
Exactly. I am not saying the judge was guilty or was not. Don't misquote me. But what I'm saying is, if it is all about discretion, then AFCC could have gone to the appellate court and said, look, so why should they start the whole process again? Why? I mean, there was the man submitted, did, and said, look, even if it was plea bargain, have you exercised your discretion within reasonable parameters as recognized by the law? If it is just that. But if there were other things discovered, that maybe he was actually compromised, right? He was influenced in exercising his discretion that way. I mean, external to the adjudicatory system. Then the man must go. He should not be suspended at all. Because you cannot, a man who is supposed to sit and preside over criminal matters, you can never entrust that kind of a man with such matters again.
But look at the matter itself, the matter at hand here. We've heard both the side of the EFCC, you know, on how they reached an agreement, and the judge breached that agreement.
Yes.
And, you know, and then we've also looked at the merit of the matter. We've looked at the judgment itself, that someone stole 1.3 billion, or was accused, or admitted to stealing 1.3 billion, and is asked to pay a fine of 750,000 naira and go home. That is not even the maximum sentence. Doesn't the NJC have a role to correct or look into that particular matter if a petition is written to it?
Now, in the realm of civil law, there's something we call terms of settlement. That is what plea bargain means in criminal jurisdiction. So, where parties outside the court sat together and say, okay, we want to settle this matter, we don't want to go through the whole process of trial. This is what we want the court to adopt as judgment in this case. That terms of settlement becomes what they call consent judgment in civil matters.
And the judge is usually privy to that.
The judge has no say. Once parties agree, all the judge has to do is to ask the first party. Even the parties don't have to be there. Their lawyers can settle the case and sign on their behalf on the terms of settlement. Once it's done, it is assumed that the lawyers have all the authority to compromise the case, whichever way they deem fit. They have been given the authority to so act. The judge has no say. In fact, the judge is not supposed to be privy to the discussions leading up to the terms of settlement. But now, in criminal jurisdiction, plea bargain comes in. So the man says, Look, he would have spoken with the prosecutor. This is what we want. This is what we want. Okay, this is what I can do. This is what I give. This, and then they all agree. Now, that is the problem. Plea bargain is coming up now because of a lot of politics, and because it has come up, it's not really the parameters within which to entertain such has not been clearly defined. You see, we have precedent. That's why we have precedent. The criminal code that we use in this country, it's not as if it was developed here. We adopted most of them. And so, even if we are going to adopt plea bargaining as part of our the jurisprudence of this country, the proper thing is to look at it from where it has reached in other jurisdictions. We should not go back to the time when it started over there. We should look at it from where it is now and say, okay, in terms of plea bargaining, no matter what, the person must go to jail if there is a jail term. The person is saying, okay, I can leave it. He's not using what he stole to buy justice, because that is what is happening now. Somebody stole money, admits it, and says, okay, I'll give you 10% of what I stole, and then you let me go.
But what you also haven't touched on is the role of the judge in a plea bargaining situation, because you've talked about civil defense and you said the judge has no role there. It's between the lawyers. But in this particular matter, what is the role of the judge?
Now, that is the point. The judge must play a prominent role, because the judge is a custodian for that purpose of the law relating to the offense that the person had been charged with. So, if for instance a prosecutor comes, otherwise, the reason, we say when you interpret statutes or documents, the golden rule is sacrosanct. What was the problem that we had, that we wanted solved, that made us introduce plea bargaining? What was the problem? From Chamberlain's perspective, the problem was we can never get these big men convicted.
Maybe not that we cannot get them convicted.
Maybe Chamberlain should tell me
the process.
Yes.
A host of people, we've heard this argument several times, that the process to get a big man convicted is usually very long,
and arduous,
cumbersome, and very expensive as well. Yes. So to save money on both the side of the prosecutor and maybe sometimes on the side of the defense as well, even though the defense might end up losing everything, they say, let's do plea bargaining.
As well as get justice.
Now, so that's your perspective. Yeah. That's what he says now. That, okay, we want to remove all the obstacles on the way to getting a conviction against the big men in our society, as well as to get justice. Justice here is two ways. To the big man and to the Nigerian, the wealth of the Commonwealth that had been stolen by him, converted to his own personal use and that of his immediate family. The justice of the matter dictates that that fund that ought to have been used to build roads so that the carnage on our roads will stop, that fund that ought to have been used to build hospitals so that you and I can walk into health facilities and receive good treatment, that fund that was taken by him, he doesn't just go home and continue to enjoy, continues to spend that money to buy favor, to buy credibility in quotes. He must atone for it, for that sin. So if that is the golden, if we want to apply the golden rule, what it means is that he is not only going to forfeit that fund, we must do something that will make it unimpressive, unattractive for people who find themselves in political offices to steal money. So if you tell somebody and he knows that if I steal 5 billion, I can part ways with 1 billion and then go home. Then the next man coming knows that, oh, I'm coming to do serious business. So he comes in and steals 5 billion and decides that I'm going to part ways with 200 million. And he does it.
Isn't that why it's very necessary to look into this type of matters? I mean, why the NJC is taking a keen interest in it, and also maybe sending a warning to judges that even if this kind of arrangement is reached behind you should exercise your discretion to know that this kind of justice will not stand.
God bless you, my sister. That's exactly what I'm saying. That the NJC is not, there's nothing keen about their interest. If all they can do is to say, oh, this judge, okay, go and then come back in 12 months. It means any judge that does it another time knows that, oh, there is precedent, I'll be suspended for 12 months,